Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I am your co-host, Thomas Vick, joined by the other co-host of this great podcast, Seth Wilson. Seth, how are you today?
I'm great. And, I like how we self-proclaim it as a great
It's a great
podcast. So that
podcast.
makes it.
That makes it true.
That's right. That's right. Well, I had some computer issues this morning, so I'm in a slightly different setup. So hopefully this will come through okay. We won't have any more technical difficulties. But it is always good to see you and get the opportunity to chat through just some estate planning questions that we see. So we've got two kind of related topics this morning that went out on your blog digest, and the first one is titled the 7 biggest mistakes people make in their wills or on their wills. So, Thomas, you want to talk through a couple of those for us?
Yeah. Well, mistake number one is procrastination. People just putting off doing their estate planning. And obviously, the problem with that is you don't know when you actually need your estate planning. You don't know when, a long-term care situation is going to come up, heart attack, stroke. You don't know when those events are going to take place. And so, and you need to have your estate planning done. You need to have a power of attorney done prior to those situations. Otherwise, you're going to be facing some difficult circumstances. So procrastination is a big mistake that people make. And I tell a lot of people that it's not really the signing of the documents or even the putting the documents together that's the difficult part. It's the discussions that go along with the documents that make it difficult, for various reasons. First of all, people don't like thinking about if and when they become incapacitated, or they don't like thinking about passing away and what's going to happen at that point in time. It's just not obviously not a pleasant topic to discuss, and so that causes people to procrastinate more and more. But these things are really important, and they need to be done. So it's the discussions around these topics that makes doing the estate planning documents difficult. Another topic that is difficult to discuss is who's going to take care of my kids if I pass away. Is that going to be my wife's family, or is it going to be my family? Is it going to be a family friend? Who's going to do that? And, who's going to handle the money for the child? Those are some of the difficult discussions that people have. And that's the reason why a lot of people procrastinate. That doesn't mean that's what they're supposed to do.
Yeah. There's a great book called Procrastinate on Purpose that helps with some of these issues, like just addressing what are the tendencies to procrastinate. How do you set things up in your own life so you're kind of working through those? So that can sometimes be it's helpful for me as an attorney, kind of reading through and recognizing those signs sometimes in my clients who are having a little bit of that hesitation to actually getting the document signed or making a decision. And I think there's a lot of reasons for that, but one is kind of that fear of, well, once I set it in place, can I change it later? And do I have everything done exactly the way I want to have it done? And I think there's some counsel that we are able to provide during these times is right now you have nothing in place. And so anything you do have is going to be better than nothing, even if it's not the most ideal. And so how do you get from sort of a pretty bad place planning wise to a better place planning wise, and then making those adjustments as you go to get it to be exactly what you want to do? And I know from my practice, and I know from talking with you, that oftentimes I will recommend, let's get the plan in place. And if we need to change it, we will. And there's not really often a cost associated with those changes if we're kind of just getting that in place, because I'd rather have my clients have that peace of mind that they have a plan, they know what the plan is, and they understand how it's going to work, even if there's still some variables that they haven't identified completely yet. Because that procrastination thing can push this to, well, maybe next year, maybe the year after. But like you say, the more times you do that, the more opportunities in the meantime there is for something to go wrong, and potentially wrong in a bad way.
Yeah, I like that. It doesn't have to be perfect. Your decisions don't have to be completely what you want, as long as you got something in place. I like that. And you can make improvements as time goes by, but get something in place, for the moment that we're living in right now.
Yeah. Yeah.
The next mistake that people make in doing their will is trying to make an estate plan on their own. And I've talked to clients or prospective clients about this. Could I just do it on my own? And what's the difference between filling something out online as opposed to coming to an attorney's office? And obviously there is some cost involved in getting an attorney, but there's more cost involved if you get it wrong. And so it's important to not do it yourself. I've had a family member send me a copy of his will recently, and I said it's not signed by all the witnesses that it's supposed to be signed by, and it was a do-it-yourself will. So we had to instruct him to go back and get it done correctly. And so there's just a lot of errors and mistakes that individuals can make. How do you notarize it? What are the witnesses that are allowed to sign a will? A family member, somebody that can take under the will, must not sign the will. That's one of the rules of executing a will properly. But attorneys' offices like yours and mine, we do will signings every week, sometimes every day in a week, and we have a lot of experience in what needs to be done, and it's just a habit of ours to do it correctly. And so you don't have any kind of concern about whether the will was executed in a proper manner. So do it yourself. Estate planning is not good. And I would add on to that with the power of attorney documents. Some power of attorney documents provide all the authority that you need. Some do-it-yourself documents that I've seen are just fine, but from an elder law perspective, an individual needs to have a certain amount of authority to be able to protect assets for Medicaid planning. And if those provisions are not in the power of attorney, I can't help that family as much as I otherwise could. And those are provisions that you're not going to necessarily be looking for when you get a power of attorney from online. You're just going to pull up a power of attorney, print it off, pay for it or whatever, and then sign it. But you're not really going to understand the provisions that are really necessary for certain circumstances. And that's where an estate planning attorney can also come in and help.
Yeah. It's a tough one, right? Because it's often a cost benefit analysis of, if I can do it cheaper, faster, myself, why wouldn't I do that? And yet a lot of times, you kind of think of the analogies that come alongside this, or the comparable situations, right? So if I have a car repair, I can do it myself. Probably not a good idea, because there's certain amount of importance riding on that repair, right? So if it's something that I'm not comfortable with or don't have experience doing, it's probably in most cases better to have the professional handle that repair than me do it myself. It's very similar in this kind of scenario, except for you have legal import in reality as a result of what you're trying to do. So I've seen, and I know you have, just various degrees of information that come in, or maybe we copy and pasted a term that we saw in somebody else's document. We didn't really know what the legal impact of that term was. And it was actually the opposite of what I wanted to accomplish. And so I think I agree with you on the sense that one of the largest problems I see with the do-it-yourself side of things is that most of the time they're not executed appropriately, which defeats the whole purpose of having the plan in place. So I would urge folks to be cautious about that. and to ensure that they do make sure that it's done correctly and go through. And that's again, it's that peace of mind. If you're hesitant because something's not quite there, what do you do next? Well, you're probably going to end up spending about the same amount of money you would have in terms of your time, effort, energy if you just hired the professional in the first place. Not that I know that from working on cars from personal experience, but
Yeah, yeah, and you could extend it out a little bit further to deeds. When an individual tries to go to the county recorder's office and do a deed on his or her own, they don't always do it the right way, and that has massive implications for how their estate is going to be distributed. And so I've seen errors with that as well. So deeds, powers of attorney, healthcare documents, wills, trusts, all of those should be done through the help of an estate planning attorney. Another mistake that individuals make is by putting their estate planning documents in their safe deposit box or in their safe. What are some obvious things that could happen if that's a mistake that an individual makes?
Well, it's all about access, right? So if you don't have access to someone's documents, even in the moment where you need them, right? So if you've got a healthcare situation but you don't have access to the healthcare powers of attorney documents, that can just it causes a big problem, because maybe then you're thinking, I don't have those documents, where in reality they exist. They're just not easily accessible to individuals. And two, it can cause an additional stressor in that moment where it's already kind of a heightened situation. And so not having access to the documents, especially from a will standpoint, can be really interesting, because you need the will to get authority to access the decedent's information in safe deposit boxes, for example. What if you don't have a copy of that to get going, right? So it can create a little bit more of an administrative challenge for folks moving forward. And so again, that's a good observation. One thing we do here for our clients is we give them all of their documents. So you always have your original documents, but we put them into a 3-ring binder. And that allows you, and it's not kind of a normal 3-ring binder that might fit everywhere. It is a little bit bigger, and so it kind of shows that that's there for a special purpose. And kind of use the analogy, break the glass in case of emergency. That's when you pull this document set out, but it's available and it's right there. And I know there's arguments to be made on security and those kind of things, but frankly, if you lose it, you can come back and re-sign an initial one. It's not too big of a deal to get that done. So it's good to have it easily accessible and available for reference.
Yes. And a lot of the documents that you would need to get into a safe deposit box would not be available if they're in a safe deposit box. So, good to make sure that those are accessible, like you mentioned. Another mistake, Seth, is an estate plan might be missing key documents. One that I could think of right now is, say you've got a trust, but you don't have a pour over will that says pour everything else into the trust if I didn't get into the trust in my lifetime. There are a lot of components to a full comprehensive estate plan, and if you miss one, there could be a critical piece missing to that. So a last will and testament is necessary in every case, but there are some other documents that could be left out if an individual does it by themselves.
Yeah, and where I see this come up is at the time we initially did some planning, I didn't want all this extra stuff. I don't need all that. I just need this. This is the problem that's top of mind right now. And I always try to counsel through that when we have those meetings or those indications of, look, I'm collecting all the information I need at this point to prepare all those documents. So it's really not that much bigger of a process while you're doing it to go ahead and get everything in place. But when clients are insistent on doing just, let's say it's a will and not the powers of attorney with the will, almost every time in a month or so, I'm getting a call hey, so and so just went into the hospital. Do we have healthcare rights? No, remember when we did this planning, you were just concerned about the will, but that factual, life scenario has changed. And so, again, just try to bring out the practicality of that as part of the planning. And obviously, we try to meet the client needs wherever they are as well. But it's really important to make sure that when you're going through that process with the lawyer, you're getting everything that you need. And if you do it yourself, obviously, then there's kind of that attendant risk that you may not know you need this additional piece of the puzzle.
Yeah. Yeah. Along with that, you might consider, if you do it yourself, you might not have all of your real estate part of your plan. And an elder law attorney or estate planning attorney is going to be talking with the client about, well, what property do you own? And they may say, oh, I got this little lot, out in Arizona or wherever it might be. And they don't really think about it. But an estate planning attorney can say, well, this is what we need to do to make sure that we get that property into the trust. And so making sure that all property is considered is important as well in doing your estate plan. Another one is an interesting mistake that people make. And, I think actually people that have this kind of asset do consider it, at least to some extent. Digital assets are sometimes not considered when an individual does his or her own estate plan. And Seth, you and I have actually had a short discussion about this recently. What do you do with, people's estate planning when it comes to cryptocurrency? It's not really a tangible personal property asset, but it's not really, it has some kind of value as well. And so you kind of have some special things to think about if cryptocurrency is in the equation.
Yeah, so to answer that, and then I want to piggyback on that because I think digital assets is an even broader
Right.
term than just what we might think of in terms of currency, right? So crypto is one of those scenarios that is really about security and it's really about access and control. And how you get access to that depends on the type of cryptocurrency it is and the platform on which it's held or traded or exchanged, and whether it's still available in the marketplace or it's back to a wallet. And is that wallet a physical wallet or a digital wallet? And so, really identifying how to get access to each of the crypto assets that may be held is really important. And how you define that in the document and keep that up to date from a password standpoint, as we know, lots of times our passwords need to be changed on a somewhat routine basis. It becomes a little bit of a challenge in the estate planning context, right? So, really having a plan and a map for how and what is going to happen and who can get access to those digital assets is really important to ensure that they are transitioned appropriately and don't get locked down because the decedent has now gone and all the information needed to access those assets are gone with them.
Yeah, and you mentioned it. Yeah, appreciate you clarifying it. Digital assets don't just include cryptocurrency. It includes our emails, our passwords, social media accounts. If you're a video game player, you could have digital assets that are worth lots of money for real in some of this digital space, which is just kind of wild to think about. But there needs to be some plan in place for that as well. Maybe it's signing up for a password service that you can provide access to a trusted individual to, and so those things are items that need to be considered as well. The next mistake that people make sometimes is failing to update your plan. And this is, it's always in the realm of judgment how often an individual should update a plan. Is it every 3 years, every 5 years? What I generally say is, 3 to 5 years is good, but it's really indicative. It's really based off of what kind of life events have happened. Has there been the birth of another child? Has there been a death in the family? Is somebody, is a child now old enough to be able to serve as a trustee or attorney, in fact? Those are, times when the estate plan should be updated. And if you don't update it, then, you might have an uncle that you named as personal representative that has been dead for 15 years serving as your personal representative, and that's actually not a nomination of anybody. So that's the sort of mistake that can happen if you don't update your estate plan.
Yeah, and I know it seems like the industry standard is kind of to say that 3 to 5 years, and one, it's an odd number, so that makes my brain hurt. And then two, if you get to that 3 year mark, and two, it's like, well, 3 years, was that 2024, 2027, 20?
Yeah.
So what I did in my practice years ago was basically just say, look, we'll just check in with our clients on an annual basis and just see if there are any things that, one, they have questions about, or two, any major life events, and just get on that cadence and rhythm. And so we don't actually do potentially a comprehensive plan of, hey, let's a review of the entire plan, but more to just have that conversation and say, hey, was there anything here? And sometimes you'll find out, well, yeah, mom and dad bought a vacation home for all the family to get together with in North Carolina or something like that. And then you realize, well, wait a minute, are you maybe going to inherit a portion of that later in your life potentially, or how's that going to work? Because now your plan, which was probably a certain way, might have real estate in multiple states, and we need to talk about what that means and what decisions do you want to make as a result. And so that's just kind of been the rhythm that we've gotten on for our clients, is just that annual check-in as well. And I don't think it hurts to wait 3 to 5 years at all, because there's usually not anything that needs to be done. But it was just easier administratively for us to say, okay, it's been about a year since you signed your documents last. What's going on? Nothing?
Yeah.
Great. Talk to you.
Yeah.
Talk to you soon.
Yeah, I think that's a great practice to have. The seventh and final mistake that an individual might make in doing an estate plan is appointing the wrong person to serve as personal representative or trustee. And that's something that we have to counsel clients on. Who is the right person to serve in this capacity as trustee, for instance? Is it going to be an individual that, say there's minor children involved? Do you want the trustee of your trust to also be the guardian? Or do you want the guardian of your kids? Or do you want there to be some kind of separation and some checks and balances between the individual taking care of your kids and then the one that's handling the money for your kids? And there can be some wisdom either way, and it really is dependent upon the particular facts of the situation, which one I kind of recommend. But yeah, having some checks and balances is a good idea. And sometimes the families will want to have co-trustees, so there's some kind of accountability there. So those are some of the discussions that I have with my clients about who should serve as a trustee.
Yeah, and there's not, like you say, there's not a one size fits all approach. And that really, I often will have that conversation with our clients, is that your family and your family dynamics far better than I do. However, these are sort of the roles that are going to need to be filled, and sort of the personality traits and skill sets that would be helpful in that scenario. So we can help walk through that discussion, and it doesn't always have to be birth order, for example, if that's not the skill set. And you'll find, I think a lot of times clients have already thought this through. Hey, so and so would be better on the healthcare side, so and so would be better on the financial side. Maybe I'd like this family unit to help out with the guardians of the minor children if something happens, but I don't want to burden them with both the children and managing the finances. So maybe we name a different trustee. But those are the different conversations that I think are really helpful in crafting that plan that says, hey, we're in good shape here, and we have a good plan in place.
Yeah. So there are 7 mistakes that people commonly make in doing their estate planning, and I'll just name them. 1, procrastination. 2, trying to make an estate plan on your own. 3, keeping estate planning documents in a safe deposit box. 4, missing key documents. 5, not accounting for digital assets in the estate plan. 6, failing to update your plan. And 7, appointing the wrong person as trustee or another representative selection. Those are 7 mistakes. I'm sure that is not an exhaustive list of mistakes that you can make in your estate plan. But we wanted to talk about one other topic just briefly. This is sort of as a notice to people, trying to get the information out there, that there's a new requirement for small businesses to file something with the Financial Crimes. What is the name of it? FinCEN is the name of it. It stands for Financial Crimes Enforcement Network. Yeah.
Yep.
And so it has to do with small businesses, those that have 20 or fewer employees are subject to this requirement, that they have to tell the federal government, FinCEN, who is the beneficial owner of their particular small business. And this just came around this year. There's been some recent legislation that has started this, and beginning January 1st, 2024, there's now a requirement that these small businesses file a report with FinCEN in order to let the federal government know who owns their business. Anything you want to add to that, Seth?
No, not in any depth, other than to state that this is applicable to a lot of my clients, because we often deal with either a small business, an LLC, an S corp type business, where it would be sort of a scenario that this may have been going on for a long time. We've not had to do this, and we're not reforming something new, so you wouldn't always know that this is coming along. And so it does apply to all businesses, but if your business was formed before this year, you have a little bit longer runway to make that reporting. So I would say, if you have an existing smaller business, just reach out to your attorney to make sure that you know what the requirements are and that you're meeting those, because there are some penalties associated with the failure to report appropriately. And it, by all accounts, at least, it seems like a fairly straightforward process for those who are going through the FinCEN website and uploading the requested information. So that's good. It seems like the website is working well to collect the information that's there. But it is just another item to add to kind of the year-end checklist on small businesses, and making sure that the appropriate disclosures are made as well. So lots of variations in there to talk about as well, just to make sure that what does get reported, and how do you define who is a beneficial owner, and those kind of things. So if there's any questions, make sure you reach out to your attorney on that to see what needs to be done.
Yeah. Very good. Well, Seth, I enjoyed it. We had a lengthier podcast today, which I thought was good. How can people get in touch with you there in Noblesville?
Well, it's always fun to chat, Thomas, so appreciate the time today. We are located here in the heart of Hamilton County in Noblesville, Indiana, and that is our web address, noblesvilleattorney.com. How about yourself?
The best way to get in touch with me is by going to vicklaw.org. I'm located here in Greenwood, Indiana, serving people with estate planning, estate administration, and elder law needs. So vicklaw.org is the best place to get in touch with me. I enjoyed it, Seth. We'll see you next time.
Sounds good, Thomas. See you later.